Welcome back to the webinar organized by Delhi University Faculty of Law Alumni Association, along with the Legal Saints. So it is often said that, when we appreciate excellence, we make it a part of our own. So this evening, let's take time to not only appreciate, but also to learn from our honorable guest for today. We have with us Mr. Anil Sapra. Okay, sir, you're already getting a lot of gratitude, heartfelt gratitude. So, the topic that we are addressing today is specific performance of contract. It is already, it is very crucial in our daily lives, okay, but then eventually um, it is very unexplored too. So, So yes, let's take an opportunity to learn from him with an experience of almost 3 decades, which is not less, more than 3 decades. We have like with an experience of 38 years, is going to tell us from the scratch, right from the drafting of the documents to the towards a successful end in the court of law. And with this, I just end it here. Very, very warm welcome, sir. Very warm welcome to you. And I hope we take a lot of things after this webinar ends. So please welcome Anil Sapra. All you guys, make sure that give him a very warm welcome. Yes, eventually this is the Coronian era, as I have usually said. But please post your comments. Please welcome Mr. Anil Sapra today.
Thank you, Trisha. First of all, I like to say good evening, everybody. I would like to first thank the organizers of this webinar. That's the Delhi University Faculty of Law, Alumni Association, and the Legal Saints for providing me this opportunity to address my views on this subject of specific performance of contracts. Before I begin my talk on this issue, I would like to first pray for everybody to have a very good health during this very difficult time of COVID-19. And I pray all the best and all the good health to you and your families. Now, with respect to the topic of today, that's the specific performance of the contract. Now, although Trisha has said that I would be dealing with also the drafting and the fighting of litigations in the courts, but I would like to first begin, and that's more important because this law or specific performance of the contracts, this is dealt with in two statutes. One is the Specific Relief Act of 1963, and the other is the Contract Act, both of which contain provisions which would be relevant with respect to the enforcement of contracts, what we call specific performance of the contracts. Now, this law, which was framed, that's the Specific Relief Act, which primarily concerns the enforcement of the contracts. This law underwent a great change in the year 2018. And there was an amendment brought in this statute in October 2018, which led to several substantial changes changes being made in the enforcement of the contracts. Now, I would just dwell on what was the situation prior to the amendment of 2018 and what has happened subsequent thereto and what is the current position. Now, prior to the amendment of this Specific Relief Act, the courts were provided with a huge amount of discretion in whether as to enforce a contract or not to enforce a contract, as to whether the contracts were to be specifically performed or not to be performed. Now, this discretion which was granted to the courts were culled out in the provisions in the Specific Relief Act itself, which at that point of time was Section 10, which provision itself made it discretionary on the courts to grant or not to grant enforcement of contracts. The provision read as the courts may grant enforcement of the contracts, then etc., 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 on one or the other reason. So this word may, which was used, itself granted discretionary powers to the court whether to enforce a contract or not to enforce it. This discretion was further culled out to be made only in circumstances which were enumerated in the section itself, which said that specific performance of the contract may be granted in the discretion of the court where there existed no standards of ascertaining the actual damages or where monetary compensation was not adequate. So the provisions which were contained itself granted the court enough leverage that in the event the contract could be or the breach could be sufficiently compensated by monetary consideration, then the courts would grant damages to the party rather than enforcing the contract. And also, if there is a situation where there were no standards to ascertain the actual damage which is caused to a party in the event of a breach, in that situation also it is up to the court not to grant the performance or enforcement of the contract. So the rule which became, or the general rule was, not to grant enforcement of the contract or the specific performance of the contract, but the rule was that it was the damages which were to be granted to the parties rather than enforcing the contracts. Now this led to a lot of problems in as much as the courts could easily find ways and excuses by saying that any breach of contract could be adequately compensated by damages. And there can't be a contract or there can't be a breach which can't be compensated in terms of money. Courts could always find one or the other reason by saying that there are sufficient standards existing by which the damages can be ascertained. So therefore, there is no need to grant specific performance or enforce the contract, and the party can easily be compensated in case of a breach committed by the other party. Now, this resulted in the contracts law being plagued with insufficient contract enforcement mechanisms, which led to the contracts or which incomplete projects. It led to the delay in projects. It led to additional cost being incurred. It led to litigation. And the result was that India was pegged as one of the worst performing contract in the way it enforced or in the way it facilitated business. Now, in the rank of World Bank ease of doing business, India stood at 130th in the report published in 2016. Now, one of the primary concerns which led to this ranking was the non-enforcement of the contracts, in which India stood at 178th, which was worse than several underdeveloped countries. Now, this led to the legislature actually amending the Specific Relief Act to provide that it should be binding on the courts in most of the events to enforce a contract rather than providing or granting damages to a party in the event of a breach. Now, the legislature therefore made these changes, and a substantial change has been brought in the Specific Relief Act. And the most important change which has been brought is in Section 10, where the word which was earlier used that the court may in its discretion enforce a contract has been substituted by saying that the court shall enforce a contract. Now, there are only very limited provisions under which the contract cannot be enforced, which are specifically provided in that section itself. And it is only in the provisions contained in section 11, subsection 2, or section 14, or section 16. If the terms or contents contained in those provisions are fulfilled, it is only in those events that the court will not enforce the contract. Rest, the court is bound to enforce a contract in the way the parties had intended and penned down in the agreement itself. Now, I must, before I take you further, point out what are these exceptions under which a contract as of present can't be enforced. Section 11, subsection 2 contemplates that in the case of a contract entered into by a trustee of a trust, in that eventuality, a contract will not be specifically performed only in the event if the trustee acted in excess of his power or he acted in breach of trust. So in that situation, a contract entered by a trust would not be specifically enforced. Otherwise, it would be specifically enforced. The other provision or the exception carved out is in section 14, which contemplated that a contract would not be specifically enforced when a party has attained substituted performance under section 20. I'll come to what substituted performance is just a little hereafter. But please note that in the event a party has obtained a substituted performance under section 20, in that event, the contract will not be specifically enforced. That is one. The other part of section 14 says that a contract which involves a continuous duty, which the court cannot monitor or supervise, in that eventuality also, a contract would not be specifically enforced. Now, this provision was already existing in the prior pre-amendment act also. The third condition was, if the contract is dependent on the personal qualification of a person, in that eventuality also a contract would not be specifically enforced. This provision was also existing. And the fourth, under section 14, the exception was that in the event the contract is determinable in nature, in that event also the contract would not be specifically enforced. Now, this determinable in nature means that if the contract contains a clause giving right to both the parties or either of the parties to terminate the contract, in that event, the courts will not specifically enforce the contract. Now, the last exception is contained in section 16 of the current Specific Relief Act, which says a specific contract, a performance would not be granted if the plaintiff, the person who approaches the court, itself becomes incapable of performing, or he violates certain material terms of the contract, or on account of some fraud, the contract cannot be enforced. The other provision under section 16 is that one who fails to prove that he was always ready and willing and continues to be ready and willing to perform his part of the contract, even in that case, the contract would not be specifically enforced. Now, these are the three sections of provisions which provide the exceptions to the enforcement of the contract. And barring these exceptions, so in the event one is falling under one of these exceptions, the court will not enforce a contract and would grant damages if they are made available. But in all other cases, no discretion is granted to the court. And if one does not come under any of these exceptions, the court is bound under the provisions of the current section 10 to enforce a contract, and there is no discretion left with the court to either enforce or not to enforce a contract. So this is one of the fundamental changes which have been brought in the current Specific Relief Act. And this is a huge step towards giving parties great power to actually conduct business, in the sense that they are pretty much sure while entering into contract that the courts will come to their help as and when it comes to enforcing a contract. So this is one fundamental change. The other point which has been changed and which has been brought into force is the introduction of section 20, which is the substituted performance I was talking about. Now, substituted performance is what you call, or what is commonly known as getting the contract executed at the risk and cost of the other party. Now, this situation arises in the event there is a breach by one of the parties, then the other party has a right under certain circumstances to get it performed to a third party or through its own agencies. Now, this, prior to the amendment, the legal framework was not clear in this regard. And there were inconsistent approach which was done, but which was adopted by the courts in India. And because of no specific provisions being made with respect to risk and cost in the Specific Relief Act earlier. Now, the new act, that's the amended act, has brought in this statutory provision of section 20. This section 20 is specifically dealing with the provision of performing the substituted performance of contracts. Now, subsection 1 of this section 20 provides the first category, where in the event of a contract being broken by one of the parties, then on account of some non-performance of any part of the contract. Now, in that event, the victim of the contract would have a right to get the contract performed by substituted performance through a third party or through its own agency, and get the cost and expenses incurred in that substituted performance recovered from the third party. So this was a relief granted that if a party chose, it could always opt for non-performance. On the event of non-performance, opt for substituted performance of the contract. But there is also a condition which has been laid that this substituted performance would not or cannot be invoked without giving a 30 days minimum notice to the other party which is at default. So a 30 days minimum notice is to be given by the victim to the defaulting party, calling upon the defaulting party to either perform the contract which is not performing or it is in breach. And in the event of the other party or the defaulting party still refusing or failing to perform the contract, in that event, the victim party would have a right to have the contract specifically performed or substitutedly performed through a third party or through its own agency, and then recover the cost and expenses incurred there. So this is a precondition in invoking substitute performance. Now, this provision also lays down that in the event a substitute performance, despite a notice being given of 30 days, the party still opts not to invoke or actually get the work executed from a third party or its own agency. In that event, it will not be entitled to recover any cost or expenses because actually it has not incurred. So that's the provision made in the subsection 2 itself. Now, subsection 3 of this section 20 lays down that if you have opted for substituted performance of the contract, in that event, you will not be entitled to specific performance of the contract, which is but obvious because if you have already opted for getting the contract or the rest of the remaining contract executed from a third party or your own agency, there is no occasion or question of getting the contract specifically performed in that way. You've got it executed through somebody else. So that's the subsection 3. And subsection 4 of section 20, this lays down that despite specific performance being, or the substituted performance having been called upon or invoked by a victim party, that will not deprive the victim party from claiming compensation for any loss that it may have incurred on account of this breach, which was caused by the defaulting party. Now, what does this mean? That compensation, because you're already taking the cost and expenses. Now, this compensation can be on several counts. Because it may have, the breach may have by the party who had defaulted, it could result in several other consequences also, like the party the party which was the victim, it losing its client because of non-performance in a particular time, etc., etc. So this provision also grants the victim party a right to get compensation in addition to the actual cost which has been incurred. So these are the fundamental provisions which have been made with regard to the substituted performance. Now, this apart, what is important is another provision which has been done away with, which was the earlier provision, section 20 of the specifically unamended act. Now, section 20 of the unamended act, it provided that the specific relief could be refused by the courts if the contract gave unfair advantage to one of the parties or the performance of the contract would involve hardship to the defendant and the enforcement of the contract would not be equitable. Now, so this gave a lot of leverage to the courts to actually stall the non-performance, stall the enforcement of the contracts, because everywhere you will find that some kind of hardship or unfair advantage is derived for one or the other party. So this was also one of the grounds in which the court used to exercise its discretion by declining specific performance and granting damages or annulling the contract altogether. So this provision, earlier section 20, where this provision, this clause was contained, this has been scrapped by the current act. So this is again a huge relief for those who are actually looking forward to enforcement of the contracts. Now, in addition, the unamended act, Specific Relief Act, provided that the contract or the plaint which is filed or instituted by a victim party should contain an averment to the fact that the victim party was always willing and ready to perform its contract or its part of the contract and continues to be willing and ready to perform its part of the contract. So there had to be a specific averment made in this regard in the plaint itself. And after making this averment, the party which was the victim had to prove this at the trial that it actually was always ready and willing and continues to be ready and willing to perform his part of the contract. Now, the provision contained that the parties must aver and prove. Now, this word aver, which is plead, has been deleted from the current amended act, And now the parties have only to prove that it was ready and willing and continues to be ready and willing to perform its part of the contract. So there is no need for one to actually plead in the suit that it was always ready and willing and continues to be ready and willing to perform its part of the contract. So looking at this earlier, the plaints used to be actually rejected on this ground that there is no averment made in the plaint that the plaintiff has been ready and willing and continues to be ready and willing to perform its part of the contracts. So this non-pleading of this readiness and willingness has been done away with, and the plaints used to be rejected under the provisions of Order 7 Rule 11. It was a very technical provision, but still plaints were rejected on this ground because the law required you need to aver that you were always ready and willing to. So this has been done away with, and only now one needs to prove and not aver in the contract. Now, one major change which has been brought in the amended act is that there has been a time limit which has been fixed in which the courts are to decide such suits for performance of the contract. This time limit is 1 year, in which the courts are bound now to decide any suit instituted for enforcement of the contracts. This 1 year is extendable by a further period of 6 months, but beyond that, there is no extension which can be granted, and the suits have to be decided. So this has given a lot, this will give, in fact, because it's a new law, will give a lot of comfort to the business community in enforcing the contracts and seeing that a remedy is obtained at the earliest possible. Now, one more provision I would like to mention before going to another important aspect. That is the provision of Section 23, which has been introduced in the Amendment Act. Now, this provision is made that even if in a contract there is a provision made that any amount is to be paid or can be paid by one party to the other party in the event of default committed by the defaulting party, it is not necessary that the courts would interpret that clause and say that yes, specific performance cannot be granted or need not be granted. And since an amount has already been categorically stated in the contract by saying that if the performance is not done, then it can be substituted by payment of a money. It is not necessary that you need to pay that amount and you can get away with the enforcement of the contract. Because one needs to see, and the courts will and are bound to see under this provision, that whether that amount which has been stated or in the contract, was it only for the purpose of securing the performance of the contract, or whether the parties actually intended that the performance can be substituted by payment of money as damages. So this needs to be seen, because it can't be averred that suppose today one enters into a contract for purchasing a property for, let's say, 1 crore of rupees, and a party has paid 5 lakhs, and in the contract there is a provision that in the event he doesn't perform or doesn't execute a sale deed within a X amount of period, in that event double the amount of money would be paid to the other party. Then it is not necessary, and the court would not, in my opinion, interpret this by saying that there was already a provision made that in the event of one party not executing or executing a sale deed, in that event he has only to pay double the money and get away with the contract, and he can just avoid the contract. That was never the meaning and could not be the meaning. This amount is kept only to ensure that it must secure the performance by the party who is now trying to default. So this provision is also introduced in the current act. So these are the major amendments which have been brought about in the act, which I'm sure would give a lot of relief to the business communities. Let me now come to one very important aspect in today's what we are facing today's this COVID-19, because I'm sure a lot of people would be looking into whether a contracts in the present scenario can still be enforced, even where the parties may be actually facing difficulties or some impossible situations in enforcing them due to lockouts or many other business difficulties one is facing. Now, let me just, now this provision, obviously, COVID-19 would certainly and is termed and would be termed by any court as a force majeure condition, because it's a condition where it is beyond it's not in the hands of any contracting party or anybody. It's a God-made or anybody's made, certainly not man-made as of today. It's a God-made eventuality. And there are a lot of businesses which have been shut down. A lot of people are not being able to go to the work. So obviously questions are bound to raise that whether in such a situation, one is still bound to perform the contract which he has already entered before this situation arose. Now, one, I would just like to say, the period today is not certain. That is, till what time one is not able to perform. Because we are in a lockdown situation for the last 1 month. The people may be facing difficulties from going to their offices or workplace or factories or manufacturing units or the working sites to perform their contracts. We don't know how long this period will continue, but let's assume it has to be a time-bound period. It may end in a few months or a few days. In the event, let's say, the period ends in a few months. And may plead that during this period, they were not able to perform the contract. And as such, either the contract should be totally abandoned and declared as having been frustrated, or this period should be excluded from the period of the contract to perform their obligations. Now, this depends on what is the nature of the contract. I'll just deal with a few contracts in this regard, because which will be very a lot of people will have questions in this regard for these contracts. Let's take the example of a tenancy agreement. Somebody has taken a commercial premises, and because of a lockdown, this commercial premises which is taken on rent, he is not able to utilize this premises for a period during which there is a lockdown, or maybe a period longer thereafter. Can under such circumstances that party plead that I am not able to pay, or I am not liable to pay the rent for the period for which I have not been able to use the premises? Now, to answer this, I would say, and that's the settled position of law, one, any force majeure circumstance in which any waiver can be granted in any regard has to be specifically be contained in the agreement itself. So there has to be a term in the agreement in which benefit of any force majeure condition needs to be provided, and it is only if that term is provided in the agreement can the party claim the benefit thereof. I'm sure in today's date, none of the tenancy agreements could have contemplated such a situation, and therefore I don't see any agreement, tenancy agreement at least, containing any term that in the event of any force majeure circumstances, no rent would be payable. So once there is no term, there is no question or occasion of any party getting advantage of the same, and it would be bound to pay the rent. So therefore, even if there was a contract, certainly then one could have availed benefit. But certainly this is not a position which has occurred on account of any default of the landlord. It's one of the business contingencies which has arisen, maybe because of A, B, or C reason. And there being no condition or term in the contract, one can't take benefit and avoid payment of rent in this regard. Let me take the other example. In the event of other agreements like manufacturing or work contracts or supply agreements, in those cases, in most of the cases in work contracts, I have found that there is always a clause in which force majeure circumstance does grant benefit to the parties, and it does say that in the event of any force majeure circumstance existing, in that eventuality, the period of completing the work would be extended by the period during which the force majeure circumstance exists. Certainly, if there is a clause, in that eventuality, the party would be able to take benefit for the period during which the lockdown is existing, or even during the period for which, for some other reason because of COVID, he is not able to supply or manufacture or whatever performance he is to do. He is not able to do that. So that extension can be granted. But certainly, one thing I must say, I don't foresee in any of such situations the contract getting frustrated. But the party can't plead that because of my being unable to perform the contract for an X amount of time, the contract should be actually declared as having been frustrated and should be declared null and void. That the law is settled in this regard, unless there is an exception in this. Unless the contract itself contemplated the same to be performed in this particular time itself. And time was made the essence of the contract, and it was stipulated in the contract that one needs to perform all these duties or obligations in the period during which this lockdown occurred. If that was the situation, then one could claim that now the contract is frustrated because it was to be performed in this period. There is no need to perform it any further because the requirement of the other party actually no longer existed after this period was over. So therefore, once COVID has come into play or is there, and there is a lockdown and I can't make these services available, so in that eventuality, the contract can frustrate. But barring that, certainly I don't see any eventuality in which the contract would frustrate. It can only lead to grant of extension in fulfilling the obligation during the period when there is a lockdown, or maybe a little longer or lesser, in which the party is unable to perform, which it has to prove. It's part of the contract because of such conditions. So maybe like labor not being available. So even after the lockdown is over, there still may be situations where the party can claim benefit or force majeure period being extended beyond the lockdown period and claim the benefit thereof and say that this period which is provided to me under the contract should be extended by this period and I should be granted similarly an equivalent time over after that period to complete the contract. So these are some of the situations. Now, one very important last point I want to make in this regard. There is a situation regarding the payment of salaries. I'm sure a few people may also be thinking that should we or should we not pay salaries despite the government's directives in this regard to pay salaries to your workers or staff? Because the situation is such that we are not earning, how do we pay the other people? We are not deriving any business as of today. Now, this contract of payment of salary is governed by individual contracts with any individual worker or staff. So it will be governed by such condition that whatever is stipulated in the contract, the employer would be governed by those conditions. I am sure those contracts would not be providing for any such situation of force majeure circumstances like the present one existing in the contract, where a salary would not be payable on account of any such situation. So the contracts not containing any such situation, there is no occasion of non-payment of any salary. Now this is purely legal. I am saying even as a humane approach, we have to pay and we should pay to the staff which may not have sufficient means like most of the business people have. We must pay in any event. But I am talking purely from the angle of law that one, if there is no provision in the contract, one is bound to pay. Apart from the humane angle that you should pay. This apart, one needs to understand another aspect, which is several notifications issued by the government of India, as well as the state governments, asking various organizations to pay their staff or members. Now, although the state notifications, I'm sure, are not mandatory in nature, and there is no legal force in those state notifications as what I have read. But certainly the central government notification of 29th of March 2020, which is a notification provided or made under Section 10, Subsection 2 of the Disaster Management Act, which provides that all concerns or all companies or all employers should pay their employees the salaries for the period of lockdown or the period during which they are unable to work. This certainly has a force of law. This certainly would be upheld in the court, barring the exception, which I still don't foresee under the present circumstance, that the courts may, it's already been challenged, I'm told, the courts may come to the conclusion that technically speaking, Section 10 of the Disaster Management Act may not be the provision which can empower the government to make a rule or law or notification pertaining to the salaries of the employees. This may be a legal argument, which to some extent may be true because the Disaster Management Act or that particular provision does not specifically say so, that the government is empowered to do this, because it is only talking about the disasters, how to manage the disasters, in which regard the governments can issue notification. But certainly it doesn't provide for payment of salary. But let me tell you, even if somebody challenges or somebody is already challenged, I am pretty sure that no court under any circumstance, looking at the difficulties faced by the employees, would entertain such a plea and hold technically that this notification was not valid or beyond the scope of Section 10, and I'm sure it will be upheld. So one would be liable to pay, whether in law or as a human approach, the salaries to its employees and staff. And on this note, I'm sure I would not go into the question of how to draft a specific one, because those things you can find in any book for drafting. And it's too wide a subject to tell you what the basics are for drafting any suit for specific performance. I would conclude my my talk on this point, and if there are any questions, I would take them. Before that, I would like to once again thank the organizers of this seminar, providing me this opportunity to speak to you. Both the organizers, that's the, let me just provide the right name, the Delhi University Faculty of Law Alumni Association and Legal Saints, for giving me this opportunity. Thank you so much. If there are any questions, please let me know, and let me see if there are something already. Trisha, you can come in. I think if there is something I can answer, if somebody needs to. You're not audible.
Yes, sir.
Yes.
Yeah, now am I audible? So there are a few questions that have been displayed on screen. If so, one by one, what we can do is display the questions. If you want to take up any, like, if that is fine.
Yes, there is a question by Mr. Dinesh. Oh, I think I've missed it. Yes, Mr. Dinesh Sabharwal is saying direction to perform contracts and claim of damages. Can it go simultaneously in single case in view of the present amendment? Now, if you are seeking enforcement of the contract, which a party has defaulted, and you are saying you can also claim damages? Yes, certainly there is no bar, because if there is a delay in enforcement or performing a contract by one party, of which the specific performance is sought by the victim party in the court of law, even in that eventuality, the party can always, if it proves that it has suffered any loss in this period during which this delay was caused, to claim damages, and the court would be fully empowered to grant these damages to the victim party, apart from enforcing the contract and saying specific performance ought to be granted. So damages is always available to a party concerned, despite the specific performance. That is one question which is propped up. Can you put some other question?
Yes, sir, sure.
Sorry, I'm having a bad throat here. Yeah. Now, Mr. Yashveer Yadav, in the absence of force majeure clause in a contract, can a party be absolved from its performance obligation on the ground of non-possibility of performance? Now, as I said, if there is no clause existing in the contract providing that a party can take benefit of force majeure circumstances, now the party cannot say that it has become, unless, yes, because the Contract Act itself provides that if the contract has become impossible of performance itself. Now, that's an eventuality. Let me tell you, most of the people think that any business difficulty is an impossibility. Now, courts have never interpreted a business difficulty as an impossibility. This can't be taken that an impossibility has occurred in performing a contract because it has become financially not viable for one party to actually perform its obligation. So that cannot be taken as an impossibility to claim that the contract has become impossible performance. Because Contract Act provides that if a contract becomes impossible performance, then certainly specific performance contract cannot be granted because the contract becomes void. So, but one needs to look whether the contract actually has become impossible of performance. So that's a very gray area, and the courts have repeatedly held that impossibility is a situation which one needs to look into very technically and to see whether actually a situation is like that as a result. The subject matter if itself, if it disappears, then certainly that can be an impossibility. But not in normal financial difficulties, that can't be termed as an impossibility. Can I take the other question? Yes, Mr. Piyush Huja. A performs his part of his part, but doesn't make the payment as per the terms of the contract. A performs his part of the contract but doesn't make the payment as per the terms of the contract. Can specific performance be revoked? I have not been able to understand it. Now, if he has performed,
Okay.
if he has performed the payment, if the performance, I think, meant that he was to make the payment, unless he says that he has supplied the goods, he has not received the payment. Of course, in that eventuality, one always had the right to seek specific performance by saying, please pay me my money. If you don't pay, then the courts will always jump in and say, yes, you need to pay. So I'm sure he means that, but he can't mean that if he has performed that he is not paid. That eventuality certainly can't arise. Then he has not performed.
All right, sir. So next is.
Yes, Mr. Rajiv Gupta. Can business contingency be part tenancy agreement, and how tenancy agreement can provide relief in case of frustration of contract? Please elaborate. Again, I am not sure I've understood this question, but I think what it means is business contingency in a tenancy agreement.
Mm-hmm.
Now, as I already said, now there cannot be an occasion of frustration of a contract. Suppose the tenancy agreement or the person has not been able to utilize the tenanted premises during the period of lockdown or a little period thereafter also. Now, it can't frustrate the contract because that period, even if it is for a period of few months and the contract or the tenancy agreement was for a period of few years, it's a business contingency which has arisen and a person was not able to utilize, just like any business, any other financial constraint which a person can otherwise also face. Apart from, he may not be able to earn from that premises. He can't say that I'm not able to earn, so I'll not pay the rent. That can't be the situation. And contract will not frustrate unless the lockdown has continued for the entire period of the contract itself or the tenancy agreement itself. Now, that will be a very rare possibility. If suppose the tenancy agreement was for a period of few months only, and for the entire period from day one, the person has not been able to utilize till the end of the agreement itself, which would be a very rare situation. And I don't see any such situation arising. So there is no occasion of frustration. It would be difficult for the person who is suffering this loss, but he has to pay because the contract would not be providing any such non-payment. So there is no occasion of a frustration arising even in those cases. Yes, please. Next question. Mr. Siddharth Shah. Yeah. In case of loss or reduction of revenue, can the party claim reduction? This is the same or ancillary payment. You know, if the parties mutually agree, which I'm sure the parties should come down, sit together. I'm sure the landlord and tenant you're talking about, in any such situation, any contract for that matter, everybody, both the parties, both today, landlord may be feeling he's the king because he's, despite the fact that this situation has arisen, he's still entitled to his rent. But adopting a humane approach, the parties should sit together and try to resolve this this so-called dispute of reduction in rent, because I'm sure landlords should understand and would understand in a situation like this that they should give some benefit to the tenant. But legally speaking, I'm sorry to say that the tenant will not be able to derive any such benefit in law. Please. Next question. Mr. Vishal Chabra. If there is a forfeiture clause in an agreement, the party can forfeit substantial part payment of 60 lakhs due to expiry. Pardon, I'm not able to hear you. Trisha? Yeah.
Yeah, substantial part payment of 60 lakhs due to the expiry of time.
I'm able to understand again this question. If there is a forfeiture clause in an agreement, whether the party can forfeit substantial part payment of 60 due to expiry of right. No. Therefore, I was saying, if there is a clause in the agreement which provides for a force majeure circumstances and a benefit being granted, suppose that there is a clause in the agreement which says that you have to, there was a clause saying that you have to perform this agreement in 2 months. And there is a clause which says that in force majeure circumstances, the party will get an extension during which the force majeure circumstance exists. In that case, the period will get extended for that period during which he was not able to perform this agreement. And that period will get extended, and there is no question of forfeiture of this, any amount which may be provided in normal circumstances. So if there is a clause of force majeure, then this would automatically get extended, or if not extended, then got extended from the court of law. But if there is no clause for providing for a benefit of forfeiture, of force majeure, then I'm sorry to say, then there will be a difficulty and the party would have a right to forfeit the amount. Yes, next.
sir. This is it for now. Like, I'm just looking for a comment where somebody said that, yeah, I started my career. Somebody is
Yeah, I know. Yes, Mr. Siddharth.
remembering.
Thank you, Siddharth.
So,
Thank you
fond
for the,
memories of you, sir.
yeah, thank you for the nice comments.
Lovely comments coming up.
There are a lot of things coming on my
So,
screen.
sir,
Yeah.
thanks a lot, sir. Thank you
Yeah.
so much
Thank you very much. Thank you. Thank you so much.
for that was a lot of people have said that that was a very and I'll show as many. There are a lot, but yeah, just a few. If,
Your voice is cracking.
thank you, sir. Thank you for being here with us.
Thank you for having me.
Hello, sir. Am I audible?
Yeah.
Yeah.
Thank you, Trisha.
So,
Thank you. Thank you, everybody.
I would like to thank Delhi University Faculty of Law Alumni Association and Rakesh Sharma sir, who helped us out with this and to begin with this and to start this very useful practical initiative, of which a lot of people are talking about. Also, heartfelt gratitude to Sandeep Sharma. Um, So yes, to all those who have missed this, I would like to say that a stream of this lecture will be available on The Legal Saints. Make sure that you subscribe, like it, and just catch him. Also, thanks a lot once again to Delhi University Faculty of Law Alumni Association.